Hi, welcome everyone. I'm Riley Stana, and it's another free webinar Friday. So getting back to it, used to do these every Friday, but got out of the habit, started seeing more people in the office again. But I missed these live streams, so back at it. I'll be here Fridays at noon. Today, we're going to be talking about how to administer an estate. So this is an important topic, whether could be for a few reasons. One, we're all going to die. We're not getting out of here alive. So this will be good information to plan your own estate. This is also relevant for your parents or your family if you're helping them with their estate. This information will be useful for that. And then also if you're a real estate investor, if you're targeting probate leads and looking to buy properties from people that have inherited properties, this will be useful information for that. So I want to talk about some basic terms, some basic estate planning terms, and then we'll get into how you should administer an estate. Let me share my screen here. Let's see. Let's do it this way. All right, so this is where I practice law, Dana and Associates, Arizona, California lawyer. Mott Legal up here. This is also my company. This runs the law firm. So I've developed some estate planning software and specific systems for attorneys under Mott Legal. And then Dana and Associates is where I practice law in Arizona and California. All right, so first thing to do, let's start by defining the players. So what's a decedent? Another word for a dead person is a decedent. And if you guys have any comments throughout this, you can leave them if you're watching live, or leave a comment. I'll go back later and try to answer those. So decedent is a dead person. Fiduciary, that's who's in charge. So it's also known as the executor. That's commonly called that, but who's in charge is the fiduciary. Beneficiary, who gets the stuff, who's entitled to receive. Be multiple beneficiaries. All right, what is an estate? So people call a large house an estate, so that's why this can be kind of confusing. So an estate, the way we use it in estate planning, means everything that a person owns, whether alive or dead. That's what their estate is. So estate planning is the process of planning where your estate goes, where everything goes. Fiduciary, the definition, it's a person to whom property or power is entrusted for the benefit of another. And then I like to use this little bookkeeper hat to signal the fiduciary, because the fiduciary has different names in different documents. Like in a trust, it's a trustee. In a power of attorney, they're the principal. Fiduciary duty. So when a person's wearing that fiduciary duty hat, they have a legal obligation. So it's a legal obligation of one party to act in the best interest of another. Last will and testament, it's a legal document. The person that makes it is called a testator. That's why it's a last will and testament. Last will and testament defines who the beneficiaries of the estate is. If there's minor children, that's where you define who the guardians will be, and the personal representative. So after a person passes away, this Uncle Sam is signifying probate. It takes some court or some government action to actually appoint these people, the personal representative and guardian. So the will says who you want to be in charge, but they have to go through the court in order to get their authority. And probate is that process where they get their authority. So this example here, she passes away. He receives the life insurance. He's named as the beneficiary, so he's able to collect that. His name is on the title for the house, so he can collect that. But this bank account just in her name, how does he collect that? So even if there's a will that lists him as the beneficiary and the one in charge, the personal representative, he's still going to have to go through court to be formally appointed as a personal representative, and then that account can be transferred. Now, there's lots of steps to probate. It takes lots of time. There's lots of filing requirements. That's why people usually want to avoid it. Okay. Intestacy. So intestate. So someone dies without a will. It's called intestate. So there's default laws that control who receives it, which family members would receive it if there is no will. If there's no family members, then it passes entirely to the state. That's pretty rare though, that they look all the way for like second cousins. And if there's no second cousins, then it would go back to the estate or back to the state. Okay. So how to administer an estate? Here's what you're going to do. So number 1, define the players. Then 2, figure out what assets are in the estate. Could be retirement accounts like an IRA, life insurance, bank accounts, real estate. And then what controls the assets? So things like IRAs and life insurance, they usually have a beneficiary. And if that beneficiary contract is filled out and it names someone, that's going to be controlling, and that does not go through probate. Something could be titled in the name of the deceased still. So like this house, it's still in the name of this person who's passed away. So we would say that it's owned by her estate. Or things could be owned by a trust. So if there's a bank account, it could list beneficiary, it could list a person, or it might name a trust to be the beneficiary, or the trust could even be the owner of the bank account. So figure out what the assets are, what's in the estate, and what controls them. So this bank account in the trust is going to be controlled by the trust. This house in the estate will be controlled by the estate. So if there is a last will and testament, that's the document that controls the estate. If there's no will, then we look at the laws of intestacy in the state that the person passed away in or was living in. Okay, so in the name of the estate could be controlled by the will that will name the beneficiaries and the personal representative, or the laws of intestacy will determine who the beneficiaries are and who has priority to serve as a personal representative of the estate. Trust will name a trustee to manage it. It will also name beneficiaries. So if you are the fiduciary, if you're listed in the trust as a trustee, or if you're listed in the will as a personal representative, then what you need to do, you need to protect the assets. So, figure out what's out there. You need to safeguard them and start an accounting. Get appointed. So if it's a will, then you need to go through the probate court to get appointed. If there's a trust, then you need to do just prove that you're the trustee. So we do a document called the acceptance of trustee that shows that you're the trustee and where you sign and accept that duty of trustee. The trust also has to get a tax ID number at that time. So there is some reporting to the federal and state governments to get appointed, whether that's a trust or in a probate. So one kind of misconception, some people think that if you have a trust that there's no work that needs to be done after you pass away. It avoids court, it avoids the probate, avoids that time, but there still is some work to do to get this person appointed. Now, after they're appointed, then you follow the instructions. So that would be what the trust says, what the will says, or what the intestacy laws say. Now, sometimes instructions aren't super clear. Sometimes they're vague or maybe even contradict another place. So that's when it gets fun. It could be a little challenging. But overall, there's that fiduciary duty. So whoever's managing the trust or the estate, you have a duty to act in the best interest of all the beneficiaries. And I recommend legal counsel for this job. Yeah, I'm biased as an attorney, but it's a matter of you don't know of what you don't know. And a lot of people come to see me after they've kind of screwed things up and gotten themselves into a little trouble maybe. And what they always say is, well, I did the best that I could. I did the best that I could. I didn't know how to do this, but I did my best. Court doesn't really care about that. If you violate that fiduciary duty, even if you're trying your best, but if you do something where it causes the assets in the trust or estate to lose value, then you're personally liable for that as the fiduciary. So that's why I recommend the legal counsel. Get someone to help you in that position to make sure you're doing things fairly and you're not going to get sued by your siblings. Create subtrust. So a lot of times a trust might create trust for the children after the parents pass away. Examples of those are an age trust. If children are underage, or someone needs to hold it until they reach a certain age, at least 18. S&T is a special needs trust or supplemental needs trust. That's for a beneficiary that's receiving government benefits, like maybe they're on disability or something like that. The special needs trust makes sure that their inheritance won't disqualify them from the benefits. And then a dynasty trust is a way to protect the inheritance that the children receive. So it's not subject to estate taxes in the future. And it's also protected from any potential creditors, like a divorcing spouse or a lawsuit from a car accident or anything like that. All right, subtrust, same thing. You gotta get a tax ID number, report to the government. You gotta collect all the assets after you get appointed and create these subtrusts. Determine valid debts. So there's a lot of claims made after someone passes away. They're not all valid. There's some things that don't necessarily have to be paid. Another reason why I recommend legal counsel. They can help people avoid unnecessary debts or help them negotiate with debts, with unsecured debts especially. And then after you pay all the debts, then it's time to divide the assets. So if you're not the one in charge, if you're not the fiduciary, you're a beneficiary, here's what you should do. So you should ask for a copy of the legal documents. So if there's a trust or a will, you want to get a copy of that just so you can understand what should be happening. And then they should be providing you an accounting. That's part of the job when you're administering a trust or when you're administering a will through probate. You need to provide an accounting, let all the beneficiaries know what assets there are and what's going on. So if they don't provide that for you, ask. And you want to ask in writing. Always ask in writing so you have proof of it. And then be patient. If you're getting response, if they're giving you an accounting, they're giving you copies of the documents, it does take time. And then you can always consult a lawyer to advise you of your rights. So if they're not giving you an accounting, if they're not giving you copies of the documents, or if you've been patient long enough and things still aren't happening, that's when it's time to get a lawyer, and they can help advise you of your rights to see if there's any funny business going on, and see if they need to get involved to help the fiduciaries do their job properly. All right, if you have to litigate, try to do it nicely. This can be really tough because in estate planning and trust administration, it's usually family members. So it can be kind of an awkward situation when it's your brother or sister or uncle that it's looking like is a bad actor. So it can be very difficult to try to approach those situations. So my recommendations, just be open and honest, ask for an accounting, and that's it. Either they give it to you or they don't. Give them time limits, and if they don't respond within time limits, then that's when you get counsel. Yeah, there we go. So hire legal counsel, set deadlines, and plan for what happens after the deadlines. So how long are you going to wait? How long are you going to wait for answers? And then what are you going to do if they don't give you answers? So legal counsel can help you in that situation, that specific situation, determine what to do. So here's my contact information for where I practice law, Arizona and California. If you'd like help with your plan, be happy to help you. I'll put our, yeah, it's all up there. We're meeting clients back in the office as well as virtually through Zoom. So if you need help updating your estate plan today, or if you're helping a family member administer their estate or trust, we can help you in that as well. Hope everyone has a great day. Let me know what you thought about this video. If there's other topics you'd like to hear about in the future, we can discuss those. Thank you.